Hello, I'm Terrell Monks, and today we're going to talk about quick and dirty estate planning, also known as the a little bit better than nothing estate planning methods. The biggest part of your better than nothing estate plan will probably be a holographic will. Holographic wills are defined in the Oklahoma statutes, and there are very few requirements. They must be fully handwritten by your own hand. They must be signed and dated at the bottom. They need no witnesses. They need no notary. As your state attorney, I would encourage you to identify somewhere in this document that it is your last will and testament, but the statute doesn't require that. It just helps us assure the judge that this was not just your personal notes about what you might do in the future. You were actually intending to write a will. If the judge doesn't believe that you were intending to write a will, then it's likely that the document we submit to the court will not be admitted as your last will and testament. So, fully in your own handwriting, preferably identified as your last will and testament, signed and dated at the bottom, and of course in it you will tell us who gets what, when they get it, and who will be in charge of your estate. In addition, the statute does not state that you must name all of your children, but there is a different statute that says that if you omit one of your children from inheritance, you must do so clearly. I'm paraphrasing, of course. So one way you can accomplish this is by saying, I have a son, John. I'm not leaving him anything in this will. That's quite good enough. You don't have to leave him a dollar. You don't have to leave him $10 or a penny. Just make it clear to the court that you haven't forgotten your son John. I recognize that we don't typically forget our children, and the court recognizes that if your child's not in there, probably you didn't forget them. But since the statute requires that you must clearly and expressly choose not to give your estate, at least in part, to your child or children, then you must at least identify those children in your last will and testament in order to assure that your gifts are honored. And it is fairly common for a husband or a wife to say that after I pass away, all of my estate goes to my surviving spouse. But to make that really effective, we need that spouse to have identified in her will all of her children, even if they don't inherit anything. A failure to name the children will leave an opening for the omitted child to make a claim against the estate and inherit. Another cheap and dirty, inexpensive estate planning technique is that you may pull from the Oklahoma statutes the statutory form of a power of attorney. Now, if you've watched my other videos, you remember that I call such powers of attorney the blank check version of estate planning because they don't have your instructions, your voice in them. But there are times when a little better than nothing is the best you can do. If you're going under surgery tomorrow and you have to do something tonight, the statutory power of attorney form is better than nothing. And a holographic will is better than nothing. But they're not good. If you're interested in good, comprehensive real estate planning, I'd encourage you to come visit one of our estate planning workshops. They're free. We don't sell anything there. We're not even set up to take your money or your credit cards in the workshop. It's just an opportunity for you to start learning what's available, what the rules are, and what we might recommend for different situations. Call us at 405 733-8686 to reserve your seat.